Hello, it's Philip Taylor speaking from Richmond Green Chambers in London. Now, this morning I'm looking at a book from Oxford University Press. It's in their series of books which come from the Oxford International Law Library. This book is on treaties. It's called Treaty Interpretation, now in a second edition and been written by Richard Gardiner. Now, it's an important book because at the moment we are looking at international treaties in a particular way, certainly concerning our membership of the European Union. And I'm not really talking about that specifically, but much more broad brush approach. But I think the book is very important for international lawyers. My wife Elizabeth and I talked about the book, and for our review of this book, we've given it the title, For International Lawyers, the Definitive Work on Interpretation of Treaties, now in a new edition. As I've said, very topical at the moment because of what Mr. Cameron's trying to do, and we'll be waiting with a bated breath to see what he gets up to. There's the book there, and then there's the side, then there's the back of the book. You see there's a nice little dust jacket, some comment about the book, and then something about the author at the bottom. He's a barrister. And then you've got details about the series of the Oxford International Law Library. The book itself runs to, it's quite a big book, it actually runs to 500 odd pages. There's an index, and then before the index you've got a bibliography. Again, very important because a lot of justification for the points that are being made. Then you get into the actual copy itself, body copy. It's got footnotes and it's got paragraph numbering. You will find, of course, that in the index the actual page numbering is given rather than paragraph numbering. Sometimes you get paragraph numbering, but here it's page numbering at the back. Now, the front of the book has, this is the front cover here, treaty interpretation, and the library is mentioned as well. You've then got the contents section. It starts off with the Vienna Rules, then part 1, then you've got a whole range of detailed contents here. You can see it runs through quite substantially, and then you've got a conclusion at the back. Part 3 is the conclusions, and then you've got after that is criticism and so forth. Then there's a foreword to the first edition, not to be confused with the foreword to the second edition, and the foreword to the preface rather to the second edition is written by Mr. Garnier. In fact, the foreword to the first edition is written by Sir Michael Wood, which is quite useful because there's a lot of foreign policy links to this. There's an acknowledgement section there. Very useful abbreviations throughout, which will give you some idea of where we are. And there's a note on citations. This is an international book. You do need to have both abbreviations and citations covered. And then you've got the case law, because it is an important legal book. Then statutes and treaties. And then you get into part 1, which is the overview, history, materials and dramatis personae. And then we start off with the Vienna Rules. And you can see the structure of the book running all the way through. It's an important book, very much for international lawyers. I think it's extremely helpful to have this in 2015 with all the things that are taking place at the moment. This is what we say about the book anyway. As the world global village grows progressively smaller, the scope, reach and importance of international law looms correspondingly larger, hence the need for the international lawyer to be able to interpret treaties in accordance with modern rules. And interestingly enough, interpreting treaties is regarded as an art by many who are experts in the field, including the author of this book, Richard Gardiner. He says, quote, "The increasing number and significance of treaties has given added importance to the art of their interpretation." I think he's right with that. Quite right indeed. Certain critics have referred to this assessment as rather too glib and have asked whether there were any rules for practicing that art. Yes, asserts the author, there are such rules. They're set out in the Vienna Convention of the Law of Treaties, signed in Vienna in May 1969, which is known as the Vienna Rules, and that's what kicks the book off. Those who would practice the art need to understand the rules, says the author, who's a practicing barrister and was a legal advisor at the FCO, the Foreign and Commonwealth Office, and he's a member of the Faculty of Law of University College London. Now this book is now in a second edition, and it sets out to explain the Vienna rules, giving examples of interpretations reached by applying them. And at the same time, no claim, of course, is made that the Vienna rules resolve all the problems of interpretation. And of course, the book doesn't have the Vienna Rules Treaty Interpretation, so you see that the title itself is slightly different. However, it's pointed out that the rules of treaty interpretation differ somewhat from typical rules for interpreting legal instruments and legislation within national legal systems. Even more importantly, the rules of treaty interpretation codified in the Vienna Convention are now applicable to virtually all treaties, both internationally and within individual national legal systems, where treaties have an impact on a wide range of matters which now grows ever larger. As I've indicated, the book's published by OUP, which is part of the International Law Library series, and it's a fully updated second edition, which features case law from a broad range of jurisdictions, and it gives an account of the work of the International Law Commission in relation to interpretive declarations. I think it's fair to say it's an impressive work of scholarship, regarded as a classic in its field, because the book builds its close and minute analysis with the support of references to real-life examples as part of its practical approach, and you've got the detail of the bibliography at the back to justify it all. And there are a number of these, from the trades union closed shop issue to the principle of freedom of speech to anti-dumping. So you've got quite a substantial cross-section here of examples. I think I'd like to conclude by saying that with its extensive footnoting, the numbering of the paragraphs throughout, an astoundingly lengthy and very useful bibliography, 12 pages long, the book also provides tables of cases, treaties and legislation, plus a detailed table of contents and the useful index which is at the back. And as a valuable resource for researchers, academics and diplomats, as well as international lawyers, we think it certainly will be regarded as indispensable for anyone professionally involved in the law of treaty interpretation based on the Vienna Rules. So thank you very much to all concerned for producing this. The publication date is cited at the 28th of February 2015. I'll just show the book again very quickly. There it is in the back. Just opening it up in the middle, a treaty. What is a treaty? There we go, you get all sorts of very interesting points. You do have a lot of footnoting. Ordinary meaning of treaties, for instance, are given there. Supplementary means of interpretation, because if you go back to your days as a student with common law, you remember interpretation, which is the role of the judiciary, is one of the main roles. You have to interpret what Parliament intends. Not the easiest thing. It's the same with this, only on a much bigger scale. It's trying to get some idea of how we actually understand when they've written something down and they've made an agreement, and you've got all sorts of people coming together and building a camel out of what looked relatively simple. Where do we go from there? Well, this book, I think, helps you immensely. So thank you very much to Richard Gardiner and all the people at OUP. It's a first-class book. Bye-bye.